Everybody, welcome back. I'm Jonathan Noble, divorce and family law attorney, licensed in Pennsylvania and New Jersey, and I get a lot of reader comments on my videos. I have thousands of subscribers on my YouTube channel. I get a lot of comments from people asking me to talk a little bit about cases that I've been involved with, things that I've seen. So I want to talk about a case that I read about lately. It was a Pennsylvania case. I wasn't involved in the case, but it is a cautionary tale. If you think that it matters how assets are titled in your marriage, you're wrong. And in this case, guy gets married, and a couple years later, his father buys a house and puts the father's name and his son's name on the title of the house, on the deed. Father pays cash for the house. He's a wealthy guy. The father and his son don't have a good relationship, but that's okay because that's not really an important part of this fact pattern. What is important is they deed the property in both of the names, the father and the son, with right of survivorship. So when father dies, the house will just revert over to the son. 21 years goes by, all right, and wife files a divorce complaint. The father died, wife files a divorce complaint, and she wants in the marital estate the value of that house. And the husband argues, wait a second, the house is in my name only. It was titled with my father and me, right of survivorship, and you didn't put anything toward any of this house. I'm the sole breadwinner or primary breadwinner. You're not entitled to the value of the house. Now, over the course of 21 years, the value of the house, I think it was purchased 21 years ago for about $175,000. So let's say it's worth $500,000 now. He wants that out of equitable distribution. And guess what? He lost. He lost. It doesn't matter. The courts ruled against him. Here's what adds insult to injury. At the end, the wife got more than 50% in equitable distribution of the marital assets. So not only was that house put into the pie, but she got more than half of the value in the end. Here's some more insult to injury in the same case. When the father died, he left around $400,000 in an IRA. That was left in an IRA to the son. And the son did what? Yeah, you guessed it. He used the money to pay marital debt. He commingled the money. Guess what? That $400,000 or whatever was left of it at divorce is a marital asset, even though it was just bequeathed to the son. But he didn't have a prenup. That's a first bad move. Secondly, he just didn't follow protocol. He commingled that gift, that inheritance, and it became a marital asset. So wife files for divorce. She not only gets more than half of the value of the house, more than half of the marital assets, and he's left with less than half. How could have this been avoided? Well, first of all, if he got a prenup, it would have helped tremendously section off those assets. Two, he could have stayed single and not gotten married, and he wouldn't have had to worry about equitable distribution because there'd be no marriage. So here's the point of the video. Do yourself a favor. If you really want to keep things separate, get a prenup. You could even get a postnup in most jurisdictions. Like if he got a postnup before the father bought the house, he could have set that asset aside and out of the marital estate. But he didn't do that. And then wife hires a smart lawyer and she ends up getting more than half because the court found that he had a higher earning capacity and she was making like, I don't know, less than $20 an hour. He got crushed. And don't let that be you, all right? Be smart. The rules are there for a reason, and the courts typically follow the rules. They really want to get it right. But if you have your head in the sand and you think that, well, my father bought this house with me, she can't touch it, you're wrong. Share this with somebody blind, walking around blind, all right, that needs to see it. Be careful out there.